Express on this 20th day, a day that is of utmost importance in the country's legal and political system. The Court of Appeal is set to decide through the 7-judge bench which way BBI will register or continue. I'm joined in studio by George Kithi, Jack Okula, Omwanza Ombati, and from our City Centre studios, Kasim Tandaza, Member of Parliament, Matuga constituency. Gentlemen, right before the break, we're talking about this doctrine, which Jack Okula sort of belabored on the point what exactly it entails. So in terms of continuation, and I'd beg to ask you, Omwanza, what exactly will BBI change in the Constitution? Will it change the structure itself from where you sit, even as those who argue that 90% of the Constitution still remains intact if BBI goes through? Well, what's your take on this?
First, I would wish to give an illustration of, a simple illustration of basic structure.
Okay.
Now, every Kenyan knows how KICC looks like, the Kenyatta International Conference or Convention Center. Now, it has the heart and then it goes down.
Yeah.
Now, if you remove the heart, will it remain KICC?
Sure it will.
I think that, no, it won't.
It
I
won't,
mean, will it be recognizable
its
as
identity.
KICC? Would you remove its identity? Because everybody, since we were born, would see photos of KICC and you'll immediately recognize it because of its heart. So I think that's a simple illustration of what basic structure is. Basic structure means that there are certain fundamentals that define what a constitution is in simple terms. For instance, in the constitution we have the presidency, which is the executive, we have the judiciary, and parliament. If you remove the judiciary, if you remove judges from the constitution, would that maintain its basic structure? I think that is the simple way of putting it about what a basic structure is. Now, the argument that the constitution would not be, altered in a very fundamental way has again to be taken into that context. There are about 77 proposed amendments in the BBI bill to the constitution. That is not a simple amendment. So one of the things that probably you would expect to change if the process goes forward is the executive, the way the executive looks. There will be an introduction of a prime minister, deputies, and then there will be an introduction of ministers who are appointed from parliament, which is not the case right now. Secondly, if again the BBI process moves forward, there will be an addition of 70 new constituencies that have been put in the new the BBI bill, and then you will have an extra, that is 70 new constituencies, so those are 70 new MPs. You would have 47 new senators, women senators, because it proposes to have male and female senators. Okay. And then on a proportion of females or members of the opposite sex who go to parliament, have to be a third. So if you go through a general election and there are fewer than a third, then the other the nominations now are not limited. They will nominate to the point whereby you have a third of the members of maybe the females or the males, depending on how the turnout is in the election. Okay. So those are the main issues that you would see, and then obviously you would have a police service which now is answerable to the executive because there is a change there. Then there is an ombudsman who's been added who can bring complaints or institute a process to remove judges. Those are the main features that I can identify that will change if the process goes forward.
Okay, so we'll see a lot of focus on that. Kasim, I know you're a politician. Perhaps as you add your voice to the focus on the process, because the Wakilis mentioned it has to be sort of people-driven. Well, what's your take on the IPPG route? And even as you add on that, people question on the bloated government. Well, what say you about the concerns that have been raised? We all know representation and oversight is quite important. But when it comes to the common taxpayer, they look at this representation as a burden at times due to the numbers that are within the parliament precincts and executive as well, which is being proposed. What say you?
First, let me address myself to the issue of the common mwananchi and representation. And I think this, I call upon the learned friends on this panel to define. Because when you say that an elected person that stops being a mere mortal, he cannot use the Wanjiku route of a popular initiative, then can we address ourselves, what about an MCA in the county assembly? Because he's also elected, can he initiate a popular initiative? And to me, to address this issue, I think the main difference between a popular initiative and the one through parliament is how it's finally determined. And for popular initiative with the referendum, and every mwananchi, every Wanjiku, including me as an elected representative, including the president, will be allowed to vote, and that vote will count. There will be no votes which will be put aside for elected members because they are not ordinary mwananchi, and for Wanjiku vote. They would all be counted one by one, and finally the tally is made. So I think these are the basic things which, personally, as an ordinary mwananchi for this matter, because I'm not a learned friend, I will look at. The issue of taxes and the bloated government. Yes, it is true, we are going to have more people in the government, we are going to have more people in parliament, and therefore more salaries paid. But if we look at what ails this country, what ails the economy, what is necessitating the increase in taxes, and in fact, to me, it's not about the increase in taxes, it's how those taxes are being used, then we have to face the elephant in the room, and this is corruption. We are losing more money. We are losing up to, I think there was a report which said up to over half of our budget through corruption. It is not through salaries. It is through corruption. Yeah. We are now faced with the issue of the debt that we are to service. Over half of what the government collects goes to repaying the debt. That is where our problems are. That is where we don't have enough money for development. That's why we might not have enough money for the critical sectors like education and health. It's not through the salaries. So I think it is good at times to actually also be bold and address what is ailing this country. Corruption, yes, and this has nothing to do with the bloated government. We cannot say there is corruption because we have more civil servants or because we have more parliamentarians. This affects us all. So, and fortunately for me, when we come to the issue of BBI, I've listened keenly what the last presenter was saying, but he didn't mention, I don't know whether it was by commission or omission, that in the BBI, it also addresses the issue of corruption. And I think this is something that we should all have embraced if we are really true to the calling of assisting Wanjiku. Because that is where most of our taxes, most of our monies, most of the services cannot be rendered because of corruption. And BBI also addresses this. So to me, I think for the betterment of this country, whether this verdict today allows BBI to continue or not, we still owe the Wanjiku, we still owe our nation to see how we can give them a better government, a better economy, a working economy for the betterment of this country. And of course, all cannot be lost, even if this verdict is not favorable to BBI. We've discussed this before. Most of the things that can actually help the ordinary mwananchi can be done through parliament, and there are those initiatives currently going on in parliament to say that we actually proceed with some of the issues. Yeah.
Okay, well noted. Kifi, as you reply, perhaps let's focus on IEBC just briefly in terms of this delimitation of constituencies. There seems to have been an intent to create 70 new constituencies and the focus on who exactly can do this. Perhaps as you also add your voice on public participation, because IEBC was of those focus around the electoral body due to this.
Thank you. Just to react very briefly on what my good friend Tandaza said is that to whom much is given, much is required. And therefore, when you're in a position of influence and you ask for that position of influence or accepted to be in that position of influence, you certainly get a status. To get a status is to lose a previous status. It means, therefore, you lose the status of a mere mortal and you become a higher mortal because you represent society. When we send our representatives as delegates to Parliament, to Senate, and we elect some of them into executive positions such as governors, we give them and clothe them with power. In fact, we give them perks and protection. They have police officers, they have chase cars, and all manner of protection, including some housing protection. We don't get that as mere mortals. When you get that, you lose your previous status, and that is the status of Wanjiku. Wanjiku is the person who is not Wanjiku. It means, therefore, either you're Wanjiku or you are not. It means if you're in power, you're not Wanjiku. And yes, Tandaza, you're not Wanjiku because you're in power. In certain instances, you will be Wanjiku contextually. But in certain contexts, you're not Wanjiku. So if the president, it comes to certain issues like right to life, he is Wanjiku. He has a right to life and any other rights. Okay. But when it comes to certain issues that the law itself picks out as delineating power of what he can do and what he can't do, then he can't do what he's supposed not to do simply because he's not Wanjiku in that context. But I must say this. Sometimes we are hard on ourselves. We put that position in law because we don't trust our leaders. And we've never had a reason to trust them anyway because of our past history. But one day, and history bears us right on this, in 1963, especially, I must say, 28th of August, J.F. Kennedy introduced the Civil Rights Bill as a reformist approach to the Constitution provisions on segregation. Now, because the black and colored people were segregated and discriminated. Now, that is what has been the advent of reformists and reform today, and what has given the black man the platform for civil liberties today, and yet that was introduced by the white man, yet the black man did not trust the white man. Even as we don't trust our leaders, because then we put checks and balances here and there, it is them that probably has a bird's eye view on how the society is. And therefore it is completely not true, therefore, and probably this then is to placate standards out there, that yes, leaders also know what is good for the people. It is just that we do not want them to start that reform. We just want to tell them what they think is good for us. Then as we start that reform approach, because that's what we said in law, and probably that's the position as we shall hear it today in the Court of Appeal, or maybe that's not the position because it may be said differently by the Court of Appeal. Okay. Now fast forward to the issue of IEBC and delineation or delimitation of the boundaries. Now look at it this way, and you know, when you're a draftsman, you draft something that you placate and try to get the society to rally behind what you have drafted, a product that shall be accepted across. So if I was the draftman, as I see it, of the BBI, this is how I would have done it, and this is how they did it. There are those positions that then are supposed to be for certain sectors of society. The executive addressed issues of the handshake. They addressed the concerns of the cycle of violence that we have. That is good for society, and nobody can argue with that. Then he says, how do people then like this? We will let people like this BBI and pass it because we are going to tell them, in fact, we're going to take resources close to them. Administration will be closer to them. And therefore, we shall increase the electoral areas, especially the 70 new constituencies. That was good for the people, and in fact, in marketing BBI as it was marketed before, that is one of the things that continuously was said. And in Central Province, for instance, or in Central Kenya, the clarion call was that we are bringing more resources. That is where the votes are. Then in Western, when you get there, you tell them we are getting new electoral areas and we have more MPs and therefore more money. And when you go to the coast, you tell them, look at it this way. You cry of marginalization. Now look, you're getting 4 or 7 more positions, and so on and so forth. And that is good for the people, because then it placates the people and they like what is, as reformists, it is addressing their issues. Now remember, when you're addressing any reform, you must address the issue that the people are suffering from. For instance, matters of economy as it is now. Now, you address the executive and the politicians. That is one sector. You address Wanjiku and what Wanjiku needs. Those are the things that my good friend here, Mwanza, has gone through and explained ably, and so on and so forth. So let's put it this way. Why we have as many propositions for reforms in the BBI as we see them today, it is because society has many interests that we need to address. Politics is about interests. And therefore, why then did we have to bring the issue of delineating boundaries, electoral boundaries, yet we know that there's a law that already subsists in terms of giving powers to the IEBC to do so? It is because, one, like I've explained, there are political interests that needed to be put together so that the cocktail is then everybody has an interest here and there, and therefore the whole movement is supported by the entirety of country. The other issue is we know that the IEBC would not in itself harness the resources and the political goodwill to bring out the change in the electoral borders as it is. But more importantly, also for political reasoning, is that IBC was not going to have a political approach. It was going to have a scientific approach to reforms, and yet BBI was going to address political issues. And therefore, yes, there's a law on reforming the electoral boundaries, delineating them afresh. But again, BBI addressed it because it was a cocktail, supposed to be a cocktail of interest in society. And more importantly also is that the question of whether then some of the issues can be dealt with by Parliament and can be dealt through a referendum. There's nothing wrong with, I think, having a wholesome amendment to the Constitution dealing with the time and money that was going to be spent by Parliament anyway to reform that which was going to be reformed in the BBI. The content of the BBI may be good. In fact, there are certain other issues that we're not going to discuss probably because of time, but many are good and many are questionable. But it's not about that now. We are talking in court today about the process. Was it the correct process?
Okay, so Jack, quite briefly, can these 70 new constituencies, in case the proponents have their way, can they apply in 2022? Are they time barred? And perhaps add your voice to the quorum issues that surrounded IEBC. Is that sorted following those new commissioners being taken into office?
Remember that Article 89 of the Constitution talks about the limitation and delineation of the boundaries, but that is a prerogative, that is a role of IEBC. So then the Constitution is also very clear that you cannot do that. You cannot delineate boundaries or even the new constituencies 12 months to the general election. It means that if we are having 12 months and already we are into the 12 months general election, we cannot add new constituencies. Unless, of course, we have decided to, my brother would say that to change the structure of the Constitution or the basic structure, we might as well, the people might as well decide to do that. Having said that, the other issue is about the quorum. Constitutionally, it says that the IBC shall consist of not less than 3 commissioners and not more than 9. So talking about quorum, constitutionally, the quorum is 3. But when it comes to IBC Act of 2011, it talks about at least 5. So then you resort to the Constitution to realize that when an act of parliament is inconsistent with the Constitution, which one becomes supreme? Of because it is the Constitution. An act of parliament cannot purport to override the Constitution. Okay. But allow me to come to what was called the basic structure.
Briefly, okay.
Historically, there were amendments, the 1963 Constitution of Kenya, 1964, 66, 75, 74, 82, 85, a raft of amendments all the way to 91, so many amendments. And when it comes to this constitution, there have been 19 attempts, including but not limited to Okoa Kenya, Punguza Mizigo, the two-third gender rule parliamentary initiative, 19 of them, 19 attempts, 19 fails. So we need to balance between what the High Court referred to as hyper amendability, that when the constitution is too flexible, then it even reduces public confidence that it can be amended as and when you want to amend it, that particularly on parliament. But we also need to guard against rigidity that creates what is called fossilization of the constitution, that you might have a constitution that you cannot amend. So what happens after that? If wananchi decide today we want to amend this constitution because we want to change its structure, what do you do with it? Okay. On the basic structure, principle and doctrine, I want to remind my senior colleagues here that there are jurisdictions that have adopted it, like India. Yeah, but in Kenya, I don't think it really applies because there is no provision in the constitution that brings that kind of limitation. If there are such limitations, then Article 255, 256, and 257 addresses the same in terms of checks and balances. Remember, we have public participation, we have the primary constituent power, we have the referendum, we have parliament, that is the National Assembly and Senate. Okay. We also have county assemblies. So these are issues, but particularly I expect that the Court of Appeal will address, and so that they can bring more light into them and we are able to move forward as a country.
Okay, Mwanza, as a footnote briefly, because we have to talk about the political side of this whole process. As you finalize on the legal side, perhaps your contribution.
I think my take on the limitation is as follows. Yeah. That the issue on whether we can have 70 new constituencies in the constitution is a political question. That is a question that has to go to the Kenyans, and then they will decide whether they want to expand the number of constituencies they want or not. Okay. That is how we agreed in 2010. However, the issue on where those constituencies will be allocated, that is a scientific question that is provided for under Article 89 of the Constitution. So that you cannot say that out of the 70 new constituencies, 35 go to Central. No, 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 no. There is already a scientific process that is provided for under the Constitution. I think that is where the BBI proponents got it wrong. Then secondly, is that even in the BBI process, from the beginning, if you read the initiative from the beginning to the end, there was no proposal from the people that were consulted that they needed their constituencies to be expanded. So that 70 new constituencies is one of the rabbits that came out of the BBI bill. And it was not originally in any of the proposals. Yeah. Yes.
It was a sweetener, yeah?
Yes, it was a sweetener.
Okay.
So that is, and then lastly, the technical question is that for you to have these 70 new constituencies, to be constituencies that are engaged in 2022, that process ought to have been done before the 8th of August 2021. So time has run out. And then again, BBI cannot go and amend itself. You cannot again amend the bill if there is a green pass and say, no, 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 no. Because we cannot attain the inclusion of 70 new constituencies, we need to change the election date.
Okay, so let's talk about politics right now. What exactly would be the political shockwave going forward of the revival or burial of the recently nullified Building Bridges initiative? I think this is the question that is in the minds of top political guns, as our reporter Murimi Mwangi just paints a picture of the likely options for top political leaders as the Friday BBI date within the court is with us. Take a look.
Consistent, unapologetic, and relentless in their quest to amend the 2010 Constitution, through the now famous Building Bridges initiative sealed in this March 9, 2018 handshake. President Uhuru Kenyatta and former Prime Minister Raila Odinga seemingly have had their fate conjoined at their political hip bones.
The moment calls us to create a constitutional order that will long endure and survive and not be a conflict-stopping constitution.
Yet with the duo still struggling on how to resume play of the BBI reggaeton after the High Court unceremoniously pressed the stop button with their May 13th verdict, Kenyatta and Odinga easily top the list of political guns most anxious about the coming Friday appellate court verdict on the BBI. For Kenyatta, analysts argue the BBI was to be a pillar of legacy for national unity, a foundation upon which Kenyatta was to also manage his Mount Kenya backyard's political future after his exit, with fresh provisions for demarcation of electoral boundaries, including constituencies with more emphasis on population quota. The BBI equally a critical political yardstick through which Kenyatta was to manage his succession, introducing amongst other goodies an expansion of the national executive to accommodate an additional post of Prime Minister and 2 deputies. A prominent proposal in the constitutional amendment push, which has been the greatest reference point of Odinga's allies in the former Prime Minister's quest for new political alliances, and a key component of their promise to millions of opposition supporters to finally find a place in government after next year's polls.
If the scenario is that where the Court of Appeal appreciates the decision of the High Court and upholds the decision of the High Court, then means that it's only the Kalenjins that will negotiate with the Luos, or the Luos negotiate with the Kambas, or Kambas negotiate with the Mijikendas. And then we shall have narrowed the gap, or narrowed the scope and the space for negotiation.
We were having a conversation with the nation. It is not something that ODM is invested in. It's just a conversation, Murini. In fact, I have said, and I can repeat here, ODM will move on so fast from this BBI conversation, you people will be shocked. Because for us, really, it is just a conversation.
Yet also caught in this anxiety are the One Kenya Alliance proponents. ANC leader Musalia Mudavadi, Wiper's Kalonzo Musyoka, Ford Kenya's Moses Wetangula, and KANU National Chairman Gideon Moi, having been key allies to the Kenyatta-Odinga axis in the push for BBI. A power struggle that has been seemingly against one man on the other side, consistently publicly mocking the BBI, but eyeing what insiders say is likelihood of cashing in on the same should the court revive the constitutional amendment push. Deputy President William Samoei Arap Ruto.
The Deputy President has been clear that he will lead a no, he shall not lead a no campaign against if BBI is allowed. So from where I stand, if they allow, the owners of BBI can proceed, they can do whatever they want, but they must be aware that the elections of 2022 must happen.
What people should be asking is, why is he opposed to a document that seems to be spreading power? Why is he opposed to a document that seems to be advocating for inclusivity? Then the opposite can only be the truth, that he would rather exercise power absolutely and have proper control.
When you think about BBI, there are a couple of things that might not be favorable to anyone. And anyway, every constitutional amendment has never been 100% for everyone. But substantially, it talks to the people, even the people who have been opposing it. And then they're talking about empowering at the local level. There cannot be any better empowerment than taking more money to the grassroots.
It is a wait and see, because as you know, in Kenya, as much as we want to rely on the legalities, there are also other machinations in between. And especially when you have a regime that uses both covert and overt power to intimidate other officers.
The timelines to the conclusion of any subsequent appeal at the Apex Court will be critical to provide closure to the referendum debate, to pave way for the August 9th, 2022 general election, A game of political cards that will inevitably have a victor and political casualties as realignments intensify in the Kenyatta succession race. Muremi Mwangi, KTN News.
Okay, so politicians are equally vested in this particular ruling by the Court of Appeal. Kasim Tandaza, let me start with you. Political quarters are pegging their future on this judgment. What does One Kenya Alliance stand to gain or lose, briefly, in terms of the possibilities out of this particular judgment?
Thank you. Before I go to the issue of One Kenya Alliance, which I'll address, I would want to put records clear, based on the previous speaker, that at no one time did Wanjiku ask for more constituencies. It's unfortunate that our learned friends normally don't actually interact with Wanjiku at the level. I'm one of those who attended these rallies. And when one asks for 1 vote, 1 shilling, what is that person asking for? You know, with the constituencies comes with a fund of CDF. For sure, there are some constituencies with very few voters, and others which have like 3 or 4 times a constituency. So that's basically what they were asking for. Whether they were asking for extra seats, nomination seats in parliament, of course, nobody went to say we don't want the 3rd gender rule to apply. So how is that going to be attained? There had to be a formula. And for the constituencies, actually, they were scientific. If you look at how they came to 70, they were basically scientific. But anyway, to the question that you've asked about One Kenya Alliance. In One Kenya Alliance, we are looking, basically, our main philosophy is the economy of this country. That is where we are starting from. And for the economy of this country, we are saying no one has all the best ideas for the economy of this country. And that is why we are looking at alliances, like-minded alliances, from different organizations, not only political parties, not only tribal kingpins, because we seem to take One Kenya Alliance and take it that it's about regional kingpins. No, that is missing the point. We are looking at like-minded people who can come together and give this country better governance, devoid of corruption, devoid of better use of the taxes that people pay, make sure that the taxes are properly used, about the debt ceiling which is affecting, that is all about One Kenya. So with the verdict that is going to come today, whether it's going to say the BBI will continue or not, I can assure Kenyans that One Kenya Alliance is not a result of the BBI, is not a result of whether we're going to have a referendum or not.
Okay, well noted.
One Kenya Alliance is about the next general election. And it is going to be there, and it's going to give good governance to this country.
Okay, due to interest of time, as we finalize, gentlemen, I know you're legal minds, but give your contribution in basically 1 minute. What impact might this have in the political landscape? Because there are 5 positions proposed in the document in terms of the executive. How big of a blow would it be to the political coalition formations? I'll start with you, Mwanza, briefly.
Yes, my take is that if the Court of Appeal upholds the High Court ruling, I think the biggest loser politically will be President Kenyatta. He effectively becomes lame duck. Because then he does not have the tools to negotiate of his so-called coalition of national building towards the 2022 general election. The biggest gainer will be obviously Ruto, because then there will be no political impetus from the president going forward. I think that will be that's the biggest political consequence of the ruling. The second is geopolitical, in that now it will be very clear that unlike Uganda, you know, where the president was able to change term limits, or Rwanda, in Kenya, the president will not be able to impose his position on the people. I think those two will be the biggest takeaways if the Court of Appeal upholds. If the appeal succeeds, it gives President Kenyatta a bit of impetus going forward, a bit of, you know, confidence.
Okay, okay.
Yes.
Okay, so due to interest of time, gentlemen, I'll have to sort of cut short your closing remarks right